immigration and to leave a lot of time to answer your questions. So thank you so much for being here with me today. So this webinar is Laid Off on an H-1B, Options to Self-Sponsor and Stay in the United States. And some of you may be laid off, and I'm so sorry, but also congratulations on this exciting new opportunity. And for those of you who have jobs, well, great, you get even extra ways to take control of your life and have freedom and just be in charge of your immigration destiny. So thank you very much for being here today. So just some housekeeping before we get started. This presentation is being recorded, and we will make a link for the recording available to registered participants. So please look for that email from my team at Alcorn Immigration Law. Additionally, this is an educational service by Alcorn. These are my lawyer disclaimers. I am not giving any single person legal advice for their specific situation. This is a general educational public presentation. So if you need legal advice, what you need to do is book a one-on-one private confidential conversation with an attorney to actually get some direction on what you should be doing. And you will see in many of these slides the QR code, which is the fastest way to book a consultation with my team and me to discuss your immigration case, your situation, your options. So to address your questions in today's call, I will be using the Q&A panel feature of Zoom. So I see that there were some questions and comments in the webinar chat, which I appreciate, but that's very difficult for me to monitor and ensure that I actually am able to answer all of your questions. So hello to everybody. Thank you for your feedback in the chat window. If you do have questions, please transfer them to the Q&A panel, because that is what I'm going to be monitoring today. And my plan with these webinars, what seems to work, I do have sometimes I can stay extra and answer more questions, which I really love to do. If you've been on my webinar, if you have been on my webinars before, you'll see that I have fun with that. But today I definitely have a hard stop at the hour. So hopefully I will be able to answer your questions. The sooner you put your questions in the Q&A panel, the higher chance there will be for me to answer them for you. You can put your questions in throughout. I'll be monitoring it. Some I'll answer at the end, but maybe some questions I can answer throughout. So that is what we are going to do today. And thank you so much for being here. And there is an option as well to ask a question as an anonymous attendee, in which case your name will not be displayed. So keep that in mind too. Okay, so here we go. By way of background, my name is Sophie Alcorn. I'm the founder of Alcorn Immigration Law and the host of the Sophie Alcorn podcast, which is available on Spotify and Apple Podcasts. Comes out every week. Had a lot of exciting new guests lately and more exciting ones coming. So there's also a wonderful archive of immigration basics how-to podcasts. I think I'm on episode 200 plus of the podcast. I started before the pandemic, and the first 50 to 75 episodes are a lot of really like classic knowledge that hasn't changed on like, how does an H-1B work? How does an O-1 work? What's an EB-1A? What's an EB-2 and IW? So those archives are very powerful for the amount of knowledge that they contain, and they're just available for free on the internet that you can access. For 4 years, I had a column at TechCrunch. That was super fun. I meditate, I'm a mom, and I just think the world should be a place where every person who's born has the opportunity to self-actualize in a safe and healthy environment and be able to work in a flow state where they can achieve their dreams. And when all of us are able to do that, the world's going to be a really amazing place. So that is the overarching thing that keeps me motivated here with immigration law at Alcorn and why I started a firm. So let's dive into it. We're talking about H-1Bs. We're talking about how H-1Bs have changed in recent years. And we're talking about why that is particularly significant for people who've already been through the lottery, who love the US, have homes here, have kids here. Maybe you're waiting a really long time for your priority date to become current. If you were born in India, it's like super long wait on the visa bulletin. But we've even seen global immigrant visa wait times increase for everybody across the board in the last few years. And so for the EB2 and EB3 categories, every country has a wait at this point. So especially when you pair that with the uncertain labor market and layoffs and the changing job market with AI, there's a lot of uncertainty for employees and a lot of opportunity for entrepreneurs. And so what I really want to focus on in today's session is if you're already in the US, you've been through the H-1B lottery and you're working at a company, how can you do side projects? How can that protect you in case of a layoff? And if you were laid off, what are the quickest and best options to be able to do your own thing as quickly as possible? So there's some key concepts we'll be talking about throughout, and I'm happy to circle back and explain. And I'll probably, touch on those core concepts as I answer all of your questions. So thank you so much already for the questions coming. So when I started my immigration law firm 10 years ago, actually 9 years and 11 months ago, I was about to start 10 years ago, I was about to start my immigration law firm. We're having our 10-year incorporation anniversary next month. So it's very exciting. But it was 2015, YC startups were starting to really take off. People thought social media was cool and exciting, and a lot of political events hadn't quite happened yet. It's a very different tone and culture in Silicon Valley and regarding technology. And the belief at that time was that if you were international, it was impossible for you to be a founder in the US unless you had gotten a green card. And that was just kind of like, oh yeah, you want to be a founder? Okay, fine. Like work in big tech, get a green card in a couple years. And then once you have your green card, you can go on and you can start your tech company. But I could tell from my earliest interactions with my clients that that was not meeting everybody's needs. And there was huge untapped potential from people with innovator and entrepreneurial mindsets to be able to create, to be able to self-actualize and work in their flow state and do interesting projects and have side projects and work in startups and tinker and advise startups and have, part-time gigs and have other streams of income. And so it's been a core, you could say barrier or challenge, but I would say opportunity of how I've been able to grow Alcorn from, being a stay-at-home mom and having this be in my kitchen when my kids were toddlers to having a team of 20 people helping thousands of people around the world and growing. But it's been a core opportunity to help identify new pathways for people to be able to live and work legally in the United States within the existing legal frameworks, and to always push at the edge of what's possible with select clients who are eyes wide open about any inherent risks or gambles in the legal strategy, where they're like, no, I know this is risky, but I want to try it because I want to see if I can make this happen, and I'm okay with filing a risky case. So back 10 years ago, the way people thought about H-1Bs was this concept of the employer-employee relationship, which was in litigation a lot of the time back then because of large consulting companies that were bringing over tech workers. And one of the factors that President Trump ran on in his first campaign was actually like ending H-1B consulting, which didn't end up happening. There was like a lot of regulation and a lot of litigation. But back then, to work in H-1B status at a company, this concept of the employer-employee relationship was interpreted by USCIS regulations as basically having somebody who can totally control you. And this was based on Old English common law principles of a master-servant relationship. And this is where we had to do all sorts of gymnastics and contortions to ensure that companies were set up with 3-member boards with a random American who had the ability to hire you and fire you and control your life. It worked, but it was really challenging for a lot of people. And I know several founders, unfortunately, who succeeded with immigration and got their H-1Bs and eventually got their green cards, but lost opportunities at billion-dollar startups that were really legit because of co-founder fallout, people on the board taking advantage of them. So since the beginning, I've been trying to find ways so that people could not be subject to those constrictions while seeking ways to build legally within the bounds of the law, and unleash their creativity. So we started making headway in this even like 5 years ago, but the law formally caught up in different ways after that. So one of the key things that happened in 2020 was that there was litigation that came in through the consulting H-1B space that changed the definition of the employer-employee relationship that we then expanded to startups. So, and we did it piecemeal, like little bit by little bit. So the litigation, which is binding federal law from a district court and overrides the regulations, it states that the employer-employee relationship concept is now going to be built on modern corporate law principles and not old-fashioned common law principles of the master-servant relationship. So we have been chipping away over the years to get more and more freedom for founders. So at first it was like, well, if there's no board and if there's just like an American CEO and an Indian CTO and they have like a 51-49 equity split, could we get the H-1B approved? Answer, yes. Okay, what if it's the CEO and they have 49% equity of outstanding shares? Could it get approved? Okay, the answer was yes. Okay. What if they own 60% of the equity? What if they own 80% of the equity? So even 3 years ago, 2-3 years ago, we started getting H-1Bs approved for 100% owners of their companies. And 2 years ago, the Biden administration announced the proposed H-1B modernization H-1B modernization rule. That was fall of 2023. And the preamble and language of that regulation recognizes the new definition from litigation from 2020 that we've already been using for several years to get self-petitioned, they're not really self-petitioned and they're not really self-employed. In the H-1B modernization rule, they call them owner beneficiaries. We have been getting owner beneficiaries who own 100% of their companies and have no 3-member board with 0 random Americans. We have been getting you H-1Bs for like 3 years now, but finally the law caught up, and that was ultimately published January 17th, 2025 as a final rule, the H-1B modernization final rule. And it's a formal acknowledgement of this new legal framework. And it clearly outlines the process for H-1B owner beneficiaries to get H-1Bs in their companies. And to this day, we continue to get those H-1Bs approved. And I'll tell you about some more case studies as we go throughout the slides. It's been an amazing development that has helped so many people get freedom. Okay, so what changed is now it's just, 100% super clear to everybody in USCIS that this binding law from litigation holds, and that the H-1Bs can be approved for people with more than majority equity in their companies. And they did create one minor restriction to ensure that companies are legit and actually making money and have the ability to pay the prevailing wage, and their person is employed in a specialty occupation. And that is that if you own more than half of your company, your first H-1B is going to be valid 18 months. The second H-1B will be valid 18 months. And then after that, you can get normal 3-year H-1Bs at your startup. So with that additional oversight, this program is fully in force and we're using it all the time. So if you have been laid off, it's really critical to be aware of the 60-day grace period. It starts after the cessation of your employment. If you're on some sort of garden leave, but still getting paychecks and still technically employed, then it would start after that usually. And it is your duty to act within those 60 days to preserve your immigration status, whether that's transferring your H-1B to another company, changing your status to H-4 through your spouse and applying for a work permit EAD if you're eligible, changing your status to B1, B2 visitor to buy 6 months to explore your options, changing status to O1, changing status to F1 with day 1 CPT to preserve your employability. There's so many options. You could also adjust your status and file an I-485, but that's like a high bar. Most people don't do that within their 60-day grace period due to the nature of the backlogs in the visa bulletin. And you could also use that time to depart and re-enter on another visa or with a new approved petition on your H-1B. So, but it's your job to make sure that you comply with that 60-day grace period if you're laid off. Now, one thing I will say on the topic of layoffs here is that if okay, here's where I'm going to go into more of these like nuts and bolts and how these things work. H-1Bs can be part-time or full-time. They can be singular or multiple. H-1Bs can be concurrent. So you can have more than one H-1B at the same time. Heck, you could even get an H-1B on behalf of a foreign company to do your work in the US if that foreign company is getting an agent. It's a little bit different than O1 agent rules, but like technically you could even have an H-1B through an agent to work at a foreign company in the US. So there are many ways to mix and match H-1Bs, many flavors. So a way to never be in the 60-day grace period is if you get a concurrent part-time H-1B, which can be as low as, I mean, the lowest I've done is 5 hours a week, but technically the form would let us do as little as 1 hour a week or even like 0.5 hours a week. I think that's probably too little and a little bit ridiculous, but so many people have been protected from a layoff because if, let's say you have, your day job, which is full-time, and then you get a part-time concurrent H-1B to do a side project. If your day job lays you off and you have that concurrent H-1B, you are still maintaining valid H-1B status. You are not in a grace period. There is no time pressure. You just keep doing that side gig. Depending on how we've structured it, like if it's a range of hours, you just amp up your hours if you need to work more, or you can go out on a job hunt and keep that H-1B for 5 hours a week. So it's layoff insurance. So that is a reason why you might want to do it. That being said, this is where we move beyond the realm of immigration law into IP law and corporate law. And at this time, my practice is only devoted to immigration law. So I can give you tips on who to talk to. But if you have a day job and you're in tech and you're at a big tech company and you want your part-time concurrent H-1B to be in your dream startup that you think is going to be, like whatever, YC, 100 billion, whatever, your IP might not be fully safe. So if you're working in a big tech company and you want to do some sort of tech side project that your current employer could potentially sue you for the IP for one day, it might be safer to just do a consulting company or another type of business with your side H-1B for now, to build up the foundation in your life to be able to have the freedom to leave your day job and then do the startup later, because you have to think about your IP. And I recorded a podcast on that. And I will put that link in the chat window and you can listen to it on how to protect your IP. And there's a number of great IP attorneys that I can introduce you to if you need help with your intellectual property. Okay, so that's the IP podcast. Next up, H-1Bs can be part-time or full-time, singular or concurrent, sponsored by a company, or if it's a foreign company, sponsored by an agent. And you can mix and match all of these in different ways. And another variable that we have at our control is the number of hours. We can either on an H-1B petition for your new company, put you in for 1 hour a week, 5 hours a week, but we can also 40 hours a week, whatever, but we can also do a range of hours. So it could be 20 to 40 hours a week, 5 to 15 hours a week. It's like whatever you want, whatever the business need is. You have to ensure that all the time you're working is authorized in the H-1B and that you're getting paid for it. But let's say, at first there's just a couple hours a week and you need to raise funding, but then you don't want to do a whole H-1B amendment later when the first angel checks come in. That's great. We can structure it so that you can naturally ramp up your hours without needing to go through the whole H-1B amendment process. Okay. So to recap where we're at today for immigrant founders, even if you own more than 50% of your company can still sponsor you legally for an H-1B. We even had the CEO immigrant founder sign their own H-1B a couple weeks ago and it got approved. So that's really exciting because it's legally allowed. It's within the bounds of the law. We can look at various roles. One of the things that can surprise people when I'm consulting with them is they think that because they studied computer science, they can only have a computer science software engineering job on a future H-1B. That's actually not true. We can evaluate all of your coursework from any degree level, as well as all of your job history from any job to determine degree equivalency. So you're not stuck. You may actually have the possibility of getting an H-1B to do a whole variety of jobs based on that type of education and experience evaluation. Now, what if you have never gotten an H-1B through the lottery before? How can you benefit from these new rules and changes? Well, there's actually a way, because you don't have to only get an H-1B through the lottery to be on H-1B status. There's another set of rules around the H-1B lottery, or the cap as it's called, about uncapped H-1Bs. And basically the laws there say that if the employer offering the job is a research nonprofit, a university, or a nonprofit affiliated with one of those types of organizations, or now, this is very exciting too, I'll talk about more about this, a company affiliated with a university or nonprofit research institution with a related job. All of those types of employers don't have to have their employee go through the lottery to get an H-1B. And now when you pair this with the other concepts that some uncapped H-1Bs exist at any time of year, it is possible to have two H-1Bs at the same time, and H-1Bs can be part-time. The way over the last 5 years that we've done for a lot of clients to get an H-1B without the lottery to work at an employer, typically a funded startup, and their person isn't O1 qualified yet, we use an external fellowship association. So that's pairing like a 5-hour-a-week H-1B through a nonprofit associated with the university, and then the full-time employer can get a normal concurrent H-1B with no lottery for full-time work at an organization that would normally be subject to the cap. So there's a new thing now that also happened in that January rule that I'm really excited to try, but I haven't, it's new, it's experimental. Basically, the new regulation says, as long as the private employer is hiring the person so that at least 50% of their time in the future H-1B job is going to do something in service of, let's just say, a university, then that private employer can directly get a singular H-1B for that person to do that job. So I imagine that if for whatever reason your funded startup needed you to work for 40 hours a week, but 21 of those were going to be spent doing research in a university lab, or mentoring students through a big program, or doing something else that benefits the university and the educational nonprofit mission, then that startup could get the employee an H-1B without the lottery. And then you're like, well, Sophie, yeah, but like, why are we going to pay somebody 21 hours a week to volunteer at a university? I'm like, okay, well, the rule just says over 50% of the time on the H-1B. So I'm imagining that we could get a 5-hour-a-week H-1B through the company to just have you volunteer and be devoted to the university. It has to be a US university. And then the same employer could get a concurrent full-time H-1B or part-time H-1B for other types of work that would typically be cap subject. This is a lot of information. You're always welcome to reach out to me for a consultation, and we can figure out how to apply it directly. Okay, so yeah, you can hold multiple H-1Bs with different employers simultaneously. This allows you to have a full-time day job and legally work part-time or full-time at a startup. Each of these H-1Bs has to exist separately. You have to go through the whole process, pay another set of filing fees, et cetera, et cetera, et cetera. Now, if you are, sorry, there's this loud noise outside, just one second. I wish for Zoom that I had a mute button for reality. Sometimes I'm like, turn off the ambulance noise, it's too loud. I'm on University Avenue in Palo Alto, so there's a lot going on outside right now. Okay, so let's talk about practical steps for H-1Bs for founders. So some of this is within the bounds of immigration, which we consult with you on to ensure your company is properly set up and we have what we need. But some of this you could do on a service like Clerky or Stripe Atlas, but probably you should hire a corporate attorney to help you with it, and we can also refer you. But you need a company. The company must legally exist. Most founders want a Delaware C corporation, but USCIS needs to ensure that your Delaware foreign corporation is properly registered in the state in which you're going to do business. So if you live in New York, New York, if you live in California, California, because wherever you're going to set up payroll, the company has to legally exist there and be able to do business. We need to make sure that your job duties, your title, your job responsibilities, the number of hours, that all of that is sound and makes sense legally. We need to file the first H-1B petition. If you're getting concurrent H-1Bs, then we need to file the second concurrent H-1B. And then there is quite a bit of compliance. There's a public access folder you need to maintain. You have to make sure that the company is paying you valid wages. If it's your startup and you go broke, I'm sorry, I hope that won't happen, but like the same rules apply where employers can't bench employees. Well, like, I'm going to keep you in the US, but there's no work for you to do, so I'm not going to pay you. That's illegal. And you can't do that to yourself either. So like if your startup runs out of money and the company can't pay you your required pay anymore, you have to leave or get another H-1B or do something, because a core requirement of the H-1B is that you're paid the prevailing wage continuously. I do really want to encourage you in this time of extremely thorough vetting to avoid anything that could be considered as unauthorized work outside of your approved employer, and even the appearance of unauthorized work, and even what you say on your LinkedIn profile, right? That can come up when you're doing visa stamping or when you're at the border. And now there's going to be this immigration OS system that's probably monitoring all those things. So now is probably a great time to do an audit of your social media footprint. Very rarely we do see USCIS site visits. They're normally targeting larger employers where they want to investigate certain patterns. There is usually supposed to be 24-hour notice on a USCIS site visit, and we are, if we can get to the geography, we are available to send attorneys to accompany an employer at a USCIS site visit. And then also it's just critical to timely extend the petition, monitor all expiration dates, H-1B max out periods, ensure you have an I-140 approved so you can get H-1B extensions beyond the original 6 years with AC-21 extensions. So there's other things you need to do to ensure you comply. But so many benefits, so many benefits. I know I've been sharing a lot and it's pretty convoluted, but there are much clearer pathways. You don't need to worry about a lot of this. It's mostly that A, this is possible, and B, you can do it. You have the flexibility to maintain your day job and your startup roles legally. There's reduced risk with things. Oh, that's other stuff in the H-1B modernization rule. But overall, predictability and program transparency. So I'm going to be switching to your questions. I see there's a lot. I'm really excited to answer them. But what you can do to keep learning about this and keep growing in the right direction is, evaluate your options. This is just one webinar. I do these webinars monthly. I have the podcast. We have tons of resources on the alcorn.law website, and we also offer consultations. Those are usually paid consultations at $300, and that allows you to speak with me. We'll come up with a detailed personal case strategy, and then if you hire us for something, we'll credit that money towards your future case. And that's where we really help assess your eligibility for cap-exempt H-1Bs, concurrent H-1Bs, H-1B modernization, rule owner beneficiary H-1Bs, how much equity you're going to own, how many co-founders you have, what your job role should be, how much money you need to put in the company. These are all things that we do in our H-1B consulting service for founders and early stage companies. That's like the pre-work necessary to ensure full setup before actually the company exists and can hire us to do the H-1B. Because there's some really specific H-1B rules, like only the company can, or the beneficiary is not allowed to pay the lawyer or the government for the H-1B fees. So typically the company has to pay for it. So you need a company set up, but what type of company do you set up? How do you set it up, right? But we can consult with you individually on that stuff. But once the H-1B company is established, it can hire us to actually engage on the H-1B for you. And we offer obviously a lot of webinars, regular updates, put a lot of attention into our social media and our newsletter. So you can follow us. We're primarily on LinkedIn and also our newsletter. But yeah, start early and stay strategic. So in terms of next steps, this is an aside, but this is fun. This is my online course. I'll put the link in the chat window. There's also a QR code, but it's 15 videos on how to become qualified for an O1A, EB1A, or EB2 NIW. And I think over 1,000 people have taken the course. Many have hired us to go on to and successfully gotten their green cards. And I've gotten feedback recently like, hey, Sophie, there's been so many of these in the market in the recent years. I created this course like 2-3 years ago. Forever. So you can just access this online. It's 15 videos, but it helped a lot of people, which I'm excited about. And the feedback I got recently was like, hey, Sophie, what I really appreciated was you actually talked about the why. You showed the RFE examples. You explained why certain evidence exists or doesn't, so that they were much better to think about the framework in their own niche fields more deeply. So that's another option if you want to go that direction. And then also we have our legal launch program. It's a 4-week evidence evaluation and assessment program with 4 meetings with our team that culminates in an attorney gap analysis consultation to talk about where you might need to improve your evidence. And of course, you can just, to start any of this or an H-1B, you can just reach out to us, and you saw the QR code. You can get to this on our website. But I have to screen for a lot of things, right, when I talk to somebody, but I tried to make the intake process as seamless as possible. So if you can help complete the questionnaire thoroughly, then that gives me an added advantage to support you in the consultation. And when you're thinking about any immigration process, yes, there are government fees. We charge for our services. And then there's also your time. And so just keeping all of those things in mind. And for our H-1B consult, so for a consultation, it's $300. For our H-1B consulting package to help ensure a new company is set up properly, but we're not corporate attorneys, so we're not going to incorporate it for you, but just to make sure you know what needs to be set up, how much money, all the details to ensure that we can have a viable H-1B. Our rate is $3,000 for an H-1B. For a brand new company, our rate is $6,250. Government filing fees are $2,010. Premium processing is optional. It's $2,805. And for H-1B extensions, our rate is $4,950. So those are data points to keep in mind. Our prices may change in the future, but that's what they are today. Try to do everything on a flat fee basis and make it as clear and transparent as possible. And we do take credit cards, but we were also able to get like a PayPal pay now or buy now, pay later situation set up for people who need payment plans. We weren't previously able to offer that, but that is a new development in case that's helpful. Okay, so now I get to go to the fun part, which is the Q&A. And I'll put the contact information up here for while we do this. And I will also where's my link? I'm just going to directly, if you already completed QR code, that's great. You can also just go directly to our questionnaire, complete that, and that'll put you in queue for resource help and to do a consultation. Okay, So I'm going to go with the Q&A panel. So if anybody put any extra questions in the webinar chat, please copy and paste them to the Q&A panel. So thank you very much for all of the questions. And due to the time and the fact that I do have a hard stop in 17 minutes, I appreciate the people raising your hands. Thank you so much. I see you. I wish I could answer your questions, but in the interest of time, I see 28 questions in the chat window. So I'm gonna do this game that I like to do and try to answer as many questions as possible. So if you put in a question and you're dozing off or multitasking or eating lunch and you really wanted to know the answer, now's the time to pay attention because I'll probably answer it quickly and it might take a few days for my team to get you the recording. Can we use our stock market portfolio to show funds for our self-sponsored H-1B? Potentially, it's not that great. It would be better to have cash in the bank account or letters of intent from future customers, but depending on what's in your stock market portfolio, maybe we can find a way to use that. If I were to get the H-1B and get married while on it, can my spouse apply for the H-4 from a different country than the country they live in? There's really long wait times in their country and also only single entry visas available since this administration. If they're able to secure an appointment in another country, they would still only get a single entry visa, but they might have a shorter wait time. It's at least worth trying, but you really can't figure out, unfortunately, where she might be able to go until you actually pay the Department of State the DS-160 visa fee. So maybe do some internet research before, see where people from her country are going, and start with that consulate. Do we need to show we're able to pay our salary for around 3 months or so to be able to open up a solo practice law firm, for example? I want to know how we qualify for the H-1B to begin with to see if I can apply for self-petitioning an H-1B. You need to show the company's ability to pay the prevailing wage throughout the 18-month duration of the requested H-1B period. So if you are going to start a brand new solo practice law firm and you have 3 months of salary and savings and a marketing plan, that's one way to demonstrate it to USCIS. If you have letters of intent from future clients, that's a great alternative way to show it. But for lawyers and other professionals, you do need to ensure that you're already licensed in the jurisdiction you want to practice in to be eligible for an H-1B. If we have a job currently and want to be prepared and just set up the LLC, but don't really do anything and only take further actions after getting laid off, is that allowed? Yeah, anybody can own a company in the US. You just can't work there. But you could do that. But then I would say that the longer the company exists, then the less investment it should receive, passive income. Like if it's just sitting there and no money is happening, then it's fine. But make sure you maintain your registrations and everything. I think it's kind of a hassle to have a random company lying around. So you could do that, but typically I encourage people to wait as long as possible to create their company until just before applying for the H-1B so that we minimize any time where there could be accusations of unauthorized work. So just keep that in mind. What is the best way to overcome the H-1B employee-employer relationship hurdle? I answered that. I love this question because we don't have to. You can own 100% of your company. I even had a guy sign his own. Very exciting. Is this option available for people on STEM OPT? So STEM has completely different rules. You can have 2 jobs on STEM. One, you can have a part-time 20-hour week on STEM. There's no H-1B prevailing wage requirement for STEM, but there is a requirement for making minimum wage in your geography. And I've had some success taking these same arguments from the world of H-1B and applying them for STEM OPT, but it is really university dependent. If you want to have your own company on STEM OPT, please talk to me before you talk to your university. because too many times I've seen people go to their university and say, "Hi, university, I'm a founder. I own all of my company and I want STEM OPT." And then the university just says no. But there are legal ways to do it. I've negotiated with universities. I've got it approved for a guy with 83% equity. So just take a more cautious approach if you're on STEM OPT. How much funds are required for self-sponsored H-1B and for what time duration? To demonstrate the ability to pay the prevailing wage for the 18-month request. And so the prevailing wage depends on your geography, your occupational code, and your wage level. And it's a mixture of investment or revenue to the company with any sort of like bootstrapping, initial seed capital angel situation. For a Canadian citizen who worked in the US for 10 years, recently got laid off on the H-1B, what is the best solution to open a self-sponsored company and transfer the H-1B, or do it as an E-2 as an investor to continue acting on the approved I-140? The H-1B is better than the E-2 because it's explicitly dual intent, whereas the E-2 might not be. And the E-2 visa, Canadians don't have to have visa interviews for H-1B, but you have to have a visa interview for an E-2, which can take a long time. And so probably the H-1B is best if you can afford the prevailing wage. Happy to talk more. Can we file a concurrent H-1B working for self-sponsorship with our current employer without them knowing? Nobody is going to tell the government about your concurrent H-1B. Everything you tell your lawyer is privileged and confidential, and USCIS does not have a practice of notifying other H-1B sponsors. The point in time where your employer might need to find out is if they're initiating the perm process or the EB-2 or EB-3 I-140 and they need your complete job history, or if you're getting to the I-485 stage of your case and their corporate attorney is doing your I-485. Have heard that the post-layoff grace period is a compassionate gesture and not a legal requirement. Is there any truth to this? Could USCIS compel a laid-off Canadian to leave before the grace period has expired? I believe that is technically correct. However, that would be a mass policy change. They would not implement this on an individual level. Everybody would be subject to it. You would definitely know about it, and it hasn't happened yet. So, and I don't think it would happen. How do I transfer my H-1B from my current employer, who I'll be leaving at the end of the month, to open a company for myself? What is the likelihood of getting an approval from USCIS? Well, we talked about it. You need to, consult with an attorney, establish the company, do the H-1B transfer. The likelihood of getting an approval from USCIS is high if you've done the setup correctly and you've disclosed everything properly and clearly explained to USCIS everything that's been going on. Also, for countries where visa stamping rules have changed, having to stamp their passport every 90 days, how does that affect my chances if I'm able to get my H-1B transferred to my self-company? Well, what I've been telling people is that in this environment of heightened scrutiny around visa stamping, that I would really prefer if my clients working on part-time H-1Bs don't do visa stamping until they're back on full-time work and have 3 recent full-time pay stubs, because I think that it's probably risky to try to do a visa stamping on a 5-hour-a-week visa. So I would say that if you want to go in the part-time direction, that you should be cautious about international travel. That I'm still recommending only essential travel to people. But if you are doing full-time, then it should be fine. Is there a path for H-1B founders to apply for the EB-2 NIW? And if yes, how long does that usually take for an Indian to get an I-140 or a green card? There is a path. Actually, EB-2 NIWs came under intense scrutiny in the last year, and I think the only viable EB-2 NIW routes are really researchers in academia or startup founders. So I'm actually telling everybody who wants an EB-2 NIW as an entrepreneur to find legal work authorization for your company and work there and get traction and build it first before applying for the NIW. So being from India, this would get you a priority date, but you would really need to upgrade later to an EB1 to get your green card in the next 5 years or so. If you don't, the wait time is decades for EB2. It sounds like a lot of the owner beneficiaries I've been helping are tech startup owners. What about business consulting firms or other types of businesses without a board or huge amount of money raised? I did one for a guy who owns a shoe company. I did one for a gal who's starting a financial advisory. So it's really the full gamut of jobs. You don't, even if you were in tech, you don't have to be stuck in a tech job for this side thing. So yeah, happy to help with anybody's business ideas here. Is change to travel visa to get additional time to search for jobs still applicable? Heard of recent examples of such cases being denied. I don't know. I have not filed many of them lately because people they do it themselves, right? So I have not been filing many changes of status to B1, B2 for people laid off. I do know that the USCIS duration to make a decision can be longer than the 6 months of requested status. So it would kind of be bad to have used the full 6 months and then be denied at month 8 and then determine that you've been out of status. So I would urge caution there. Can you apply for a visitor visa within the US while on your H-1B visa? Can you hold both visas at once? Well, the visa in your passport is different than your status in the US. So if you're in the US and you want to become a visitor, you can do a change of status from H-1B to B1 or B2 and no longer be in H-1B status. Or you can apply for a visitor visa in your passport. You could have multiple visas in your passport, but every time you come to the US, you have to pick one status to be in at the same time, to be in on. I've been a co-founder for a startup for more than 4 years. Can I use it to change my status from TPS to a green card? Potentially, yes. I have done this. It's complex, but it's possible. And you should simply reach out for a consultation. It's worth discussing. Can you file a concurrent H-1B part-time if you have one full-time and you work for the second company for 5 hours a week? Would this be considered part-time? It would be considered part-time and you can do it, yes. How soon after you get an H-1B in your own company can you file for EB-2? Immediately. How many months or years of salary must you show? None. What is the minimum you need to show? That's a different topic for a different webinar. You can look on my YouTube channel to find past webinars that talk about EB2, NIW, and EB1A requirements. But you really have to show traction and that what you're building is good for America. And it's not like a mom and pop restaurant, but it's like something with impact for the country or the world. Can one just work for a CAP exempt org for 5 hours? Yes. Would that raise an issue when getting the H-1B stamp? Yes. I talked about that. Explain how they audit us and how to protect ourselves from social media. Well, I don't know all the ways they can audit you. I know they are increasing with AI and machine learning, but on your DS-160 visa application, you have to disclose all social media handles. And there are reports of people at the airport having the government people make them open their LinkedIn and show the profile. So I think there's a variety of ways this can happen. Can you talk about the part-time H-1B avenue a bit more? What if our full-time job is connected to the H-1B and we get laid off? Do you recommend getting a part-time job? Yep, we've talked about that extensively. If you have a part-time concurrent H-1B, then if you're laid off, you're not in the grace period. Is a layoff on its way? If a layoff is on its way and the company wanted to help with some extra time, would an unpaid leave before the layoff happens be legal? You can't do benching on H-1B, so you have to get paid to be valid. Oh, thank you for the compliment. I appreciate it. Thank you so much. Okay, next question. 3 more minutes. Are we hiring? Oh, are we hiring? Yes. Not formally, but I'm exploring new job opportunities for young attorneys or people earlier in their careers. My goal is to solve immigration for the world. So I will need other attorneys helping me with that goal. So if you're interested in working with me, please reach out. If not now, I would love to keep in touch for the future and look for ways to collaborate together. Our H-1B, repeating the fees, a consultation is $300, startup consulting is $3,000, and brand new H-1B for a new company is $62.50, and an extension is $49.50, and this is exclusive of government filing fees. Oh, somebody says the complimentary course is still charging $990 via Teachable. That should not be the case. If you could please email hello@alcorn.law on the bottom left of the screen and ask for the complimentary link and let my team know that it's charging. That's a mistake, and I would love to get that corrected. So thank you so much. Can I sponsor using my tech startup but no funding raised yet? You can. How much funds do you need to add to your corporate bank account? It depends on when you think you're going to raise, how much savings you have, if you and your co-founder are going to do a loan or an investment. Definitely worth discussing further, but I've gotten H-1Bs approved for people with as little as $8,000 in the bank account. I don't recommend it, but it is possible. Currently, I'm outside the US with a valid H-1B visa stamp. If I apply for an H-1B for as a owner beneficiary, do I have to get a new visa stamp? Nope, you can travel back on the same stamp. And if you've already been subject to the lottery, you don't have to worry about the cap exempt stuff. You're good. After a change of status approval within 60 days of H-1 termination, can we get the remaining days back on the previous H-1? I don't know. I'd have to research for you. That is way too in the weeds for me right now. Sorry. How much funds are needed in the company's bank account to get self-sponsored H-1B approved? TBD, collaborative, depends on the nature of your business. Is it dependent on the number of hours? Yes, absolutely. What is the wage of the CEO? Well, it depends on where you are geographically and what your degree was in and what type of CEO job you're doing. Is the part-time concurrent option for people on STEM OPT who are employed? We covered that. You're welcome. I've heard that the post-layoff grace period. Oh, you guys are duplicating your questions. Why'd you do that? Does angel investing in 2 to 3 startups help with the O1 or EB1? Yeah, if they're successful, yeah. But probably for judging and leading in critical role, maybe. I'm an employer. What happens if we lay off an employee after H-1B filing, but before approval? Does their case stay active, or do we have to wait until it's approved? If you just got it for them in the lottery, I would recommend waiting until it's approved. That way you can ensure they've been counted against the cap and they're able to reuse that in the future. If it's in the lottery and you lay them off before the approval, they lose their spot in the lottery, which could be pretty devastating for somebody. But if it's just a transfer and they already got through the lottery years ago, it doesn't matter. Is there a specific month to apply for the new H-1B? Yes, the lottery happens in March. We start taking cases in December. Can a startup that has been incorporated with you as the owner that is still in the process of fundraising transfer your H-1B visa? Yes, absolutely. We'll be more creative about the funding, but we can do that. If your priority date is current, but you got laid off, is the H-1B an option to explore pending when you can get a new job, considering there's a new request to appear before USCIS for EB green card approvals? I don't know what you're asking me. I'm sorry. But look, if you got laid off and you're trying to stay in the US, I would say that's the immediate problem to solve. As long as you do everything legitimately, we can sort out the green card stuff later. The pricing for filing a part-time H-1B when setting up your business is $3,000 for the consulting phase and $62.50 for the H-1B. The government filing fees are $20.10, and if you want premium processing, it's $28.05. And I will explain what if that is even necessary for you if you consult with me. Being out of status limits you from working and living in the US in the future. Yes, if you have more than 180 days being out of status and you leave, you can't come back in for 3 years. If it's more than a year and you leave, you can't come back in for 10 years. Would showing savings for 3 months covering the prevailing wage be enough? Potentially, if you have a clear business plan for how you're going to get other funding to pay the prevailing wage after month 3. And thank you so much for completing the questionnaire. And I'm looking for the consultation as well. And thank you, everybody. I'm so glad this was helpful. If this was helpful for you, I would love some Google reviews for our Palo Alto and New York offices. So if you would want to do that, I would really appreciate it because I do these webinars for free. I hope it helped you. Thank you so much for being here today. And thank you so much and have a wonderful rest of your day. Keep in touch.